So let us now discuss the concept of fundamental state rights under public international law. Of course, what are the fundamental rights of a state? Okay, so authors would provide 5 fundamental rights of a state. So the first one would be the right to existence and self-defense, the right to sovereignty and independence, the right to equality, the right to property and jurisdiction, and the right of legation and diplomatic intercourse. So of course this is a little bit long topic, so we have to of course discuss one by one. But of course the last one, right to property and jurisdiction, will have a I think if you can recall your Consti 1, there's already discussion on the national territory. So most of the discussions, you can relate this in the national territory aspect. When we speak of right of legation or diplomatic intercourse, this is the power or the right of a state to send its diplomatic and consular officers. So some chapters in other books by authors, they discuss this in a separate. Of course, they're discussed separately, but sometimes the title is not right of legation. If you're going to read the subtitle as law, diplomatic and consular laws, that's of a similar import. All right. Okay, so let's discuss first, of course, the right to existence and self-defense. So we have this Article 51 of the UN Charter. Okay, so if we're going to read Article 51, of course, it states there that nothing in the present charter shall impair the inherent right or individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members of the exercise of its right of self-defense shall be immediately reported to the Security Council and shall not in any way affect the authority and responsibility of the Security Council under the present charter to take at any time such action as it deems necessary to order to maintain or restore international peace and security. So what's the general rule here? Of course, the general rule here would depend on what kind of state are you. Of course, there is this concept of self-defense. Of course, before we go to that, let's relate this to Article 52, Paragraph 1 of the UN Charter. So, nothing in the present charter precludes the existence of regional arrangements or agencies in dealing with such matters relating to the maintenance of international peace and security as are appropriate for regional action, provided that such arrangements or agencies and their activities are consistent with the purposes and principles of the United Nations. Now let's go back. Okay, so of course you're going to read this plainly. Article 51 of the UN Charter. As a rule, they renounce the concept of war. Actually, this is a renouncement of war on the part of the United Nations organization. But is that absolute? Of course, the answer there is it's not absolute as long as you're going to invoke self-defense. And also in invoking self-defense, it does not stop a nation invoking self-defense to activate or to utilize this concept of a collective defense arrangement. Okay? But in the point of view of Article 51 of the UN Charter, you may have to wonder, so what is self-defense by itself? It's not necessarily hard and fast and equally attributable to every nation. You have to also consider the factors or the current political situation or political or international situation of a state. So what I'm saying, so for example, we always see Israel doing some activities which of course to the chagrin of Palestinians. Of course they are now protesting right now as we speak. They're protesting now as to atrocities made by Israeli soldiers and other agents. Okay, but note that Israel has been applying the concept of self-defense peculiarly. Why? Since they have the arms, since they have the They have the military capability. They can always say that since they're a small country and this has been their, you know, this has been happening since their independence. They're very much aware of protecting their state. They're in they're what we see now as Israel right now. They still believe on the fact that Arabs are surrounding them, does not really want their presence there in the Middle East. Okay, that is why they have to fight. That is why that's why if they're going to do a preemptive strike, it would appear that it's sympathetic to them more than not. Okay, and you can see that in all of the activities of Israel. They have used a lot of things, especially with their secret service, di ba? Kitang-kita nyo naman na gano'n ang ginagawa. But what I'm saying is, sa point of view nila, they can invoke self-defense. But if we are, let's say, the Philippines as a third world country, although since we do not have the capability, okay, right now, our interpretation of Article 51 would be conservative in nature. This is going to be conservative right now, in a sense that, well, you have to look at the factors if it is realistic. Can we really do an attack? Let's say the issue is with China. What can the Philippines do? Of course, it can file diplomatic protest, but short of saying, they cannot really do something assertively because number one, China was the bully. Number two, if they fought back the bully, more or less, there would be an escalation of possible armed conflict. Diba? That's the inevitability of that. So, mangyari talo ka ngayon pag nagkaroon ng giyera. Okay? Alright, then, of course, what would be the purposes of course, we mentioned Article 52, Paragraph 1 on defense arrangements. So what are defense arrangements? What are their purposes? So of course, these arrangements, of course, the main purpose is for the balance of power. Considering that no state shall be in a position to have mastery and dominion over others. Alright? Then, how are you going to justify self-defense? So of course, the ideal scenario is, of course, the presence of an armed attack. Of course, this concept, however, has been eroded as states improve their weapons and war material and war strategies. That sometimes offense is the best defense. Of course, if you can recall the bombing of Japan by bombing of atomic bombs in Hiroshima and Nagasaki, note that the US did not just bomb them out of the living daylights. Of course, they wanted to just bomb them because they're part of the war. The reason why the bomb was used is practically to put an end to war and to create peace. Actually, that's the ironic. Come to think of it, it's a bit ironic that, well, someone really has 60 to 100,000 people has to die just to attain that peace. Okay, so that's about it on self-defense. Of course, we have now this concept of aggression. So of course, under UN Resolution Treaty 14 series of 1974, the use of international force against the sovereignty, territory, and independence of another state. So this would be a crime of international peace. It can give rise to international responsibility. Of course, if you read your Resolution 314, there are enumerations. I think there are 7 enumerations, okay, which defines acts of aggression. And I think, just an opinion, of course, I think China has already read this. Napapansin nyo naman, di ba, yung kanilang tactics, di ba, sa news, they call the tactics as gray zone tactics. Because look, if they're going to go overboard, what are those included in the acts of aggression under UN Resolution 314? Of course, they cannot wage the bullying, but they have to modify the way they are doing the bullying. Kaya nga, nagkaroon ng gray area tactics, as we have heard sa news. The point there is, diba, yung aggression mo, it's going to be, call this, yung aggression nyo is going to be it's going to be manifested, di ba? In a sense, it's going to be manifested. All right, so just look at the kinds of acts of aggression. Then you have to compare it, as I said, you have to compare it with, of course, what China is doing. They're trying, as I said, they might have read this, but what they're doing is, of course, they just have to go short to that, to that act, so that, well, they would have this flimsy but, well, valid defense that, well, we have complied with the UN resolution. You cannot hold us for aggression. But I don't know if this will change. It's just happening that, well, the complaints will always be far in between, di ba? But eventually, I just hope, of course, inevitably there would not be this, an aftermath that maybe have serious consequences like war, di ba? Kasi kahit na gini-gray area tactics ng China yan, yun nga parang hinihintay niya I think China is waiting as to someone is going to give up, diba? Yun lang ang mangyayari kasi dyan Alright, so then we have, of course, we've done with right to existence and self-defense. So we have now the right of independence. So when we speak of independence, I have repeatedly stated this in Constitutional Law 1. When we speak of right of independence, it refers to the right which pertains to external sovereignty. So, of course, what is external sovereignty? It's the freedom of the state to conduct its own foreign affairs, which includes entering into treaties, makes peace, war, and enter into diplomatic relations. So, it is freedom from control from any other state and not freedom from the restrictions binding on all states joining the family of nations. Then we have, of course, this concept with respect to right of independence. You have to distinguish it with the concept of intervention. So what is an intervention? An intervention is an act of the state to interfere into the domestic and foreign affairs of another through the employment of threat or force. Of course, it is recommended that states must abstain from intervening into the affairs of another state, except only if this is invoked only for reasons of self-defense, provided self-defense is existing per se, and as well as there should be humanitarian on other justifiable grounds. Okay. Of course, you have to relate the concept of intervention with, of course, the concept of an independent foreign policy, because as we maintain, we do not really side with one superpower or another. To be fair with us, we still comply with an independent foreign policy. There would always be this trend, who to support. Do you want US? Okay. Do you want China? It's still going to be a trend. Okay. The trend is it's just, if it's going to be a trend, diba? It's there is no permanence in if it is just a mere trend. You have to consider everything. You have to consider everything as to invoking self-defense. Okay. And also, how are you going, you should put this way. So when we speak of a foreign policy, okay, it should be independent. So again, going back to our discussion and to Consti 1, you cannot what is being stated by an independent foreign policy is, well, we are just doing our best to balance the diplomatic relations between two states. Sometimes if one would gain something on the economic side, we're going to side with another. Okay, we're going to side with one state, diba? For example, gusto natin ng arms. We're now close to the United States. Nung previous administration, they wanted to deal with China. they're close with China, diba? Ganun ang nangyayari. But does it necessarily mean that there is intervention, as well as would it violate independent foreign policy? The answer there is no. It would not violate those two concerns. Okay, especially yung independent foreign policy. I think naman the DFA has made a balanced anticipation on these things while they are planning. All right, they're planning as to whose nation are they going to ask for help. Okay, whose nation would be gaining a majority support from other foreign states as to the Philippines. All right. Okay. Then of course we have the Drago Doctrine. Actually related to sa this is related to this concept of sinasabi lang kasama to sa Estrada and Calvo clause. So what happened here sa Drago Doctrine? So to si Venezuela, he has this, Venezuela has this debt. Okay? It's a very, very large debt with other states. Siyempre wala silang magawa di ba? So wala magawa siyempre yung other states na may utang si Venezuela sa kanila. What they did was they organized a blockade para maparsa magbayad ng utang ang Venezuela at that time. What happened was, there came the Drago Doctrine. So, ang sinasabi nila sa Drago Doctrine, hindi kami papayag, kasi Drago is a Venezuelan minister, okay? Sabi ni Drago, hindi kami papayag na ma-blockade kami dahil lang sa utang kontraktual, okay? Hindi sila pumayag na yun lang yung magiging dahilan. And they cannot force, a state cannot force another state to settle its debts through blockades or other. Kasi later on we're going to discuss about settlement. Isa yun sa mga yung blockading, reprisals, retortions. These are questionable acts against states. Okay. So it is recommended that they should the recommendation here is, of course, the states cannot use a blockade to force as a nation like Venezuela to pay their debts. But it is because of this incident on the Drago Doctrine that there is already later on there is this Hague Convention of 1907. So your Hague Convention of 1907, of course, number one, this is the treaty which is now the foundation of international commercial arbitration. Also, of course, there is a clause there in the Hague Convention of 1907 which states that the contracting powers agree not to have recourse for the recovery of contract debts claimed from the government of another country as due to its national. So this is your Drago clause, or some would say that this is called the Drago-Porter Resolution Clause. So essentially, the doctrine of Drago was inserted in our Hague Convention. It just means that you cannot use armed force, or you cannot use any reprisals or any retortions under international. Of course, these are not allowed under international law in order to recover obligations or debts. Alright. Then we have now the right to equality. Of course, the right to equality, it is in your Article 2 of your UN Charter. So of course, you would see there that the UN organization is based on the principle of sovereign equality of all its members. And of course, we have to relate this again to the Montevideo Convention of 1933, that states are juridically equal, they enjoy the same rights, and have equal capacity in their exercise. Then, of course, what would be the presence or principle of equality? So, all rights of the state, regardless of their number, must be observed and respected by the international community in the same manner that the rights of the other states are observed and respected. So, all states, be it big or small, powerful or weak, have an equal right to the enjoyment of all their respective attributes as members of the family of nations. What would be the manifestations of this equality? Of course, you would see in the UN General Assembly, it's going to be one vote for each state. At least that tempers the voting arrangement in your Security Council. Okay, then there would be right for protection of nationals. Then with compliance with the PIL principles, and of course the principle of pari in parem non habet imperium. A strong state cannot assume jurisdiction over another state, no matter how weak, or question the validity of its acts, insofar as they are made to effect within their own territory. Of course, this, as I said, this has been heavily used in sovereign immunity amid states. Okay, of course, there is compliance with pari in haben non parem imperium, in order to not to unjustly vex the peace of nations. And of course, legal and factual equality. Of course, there's an issue, of course, on legal and factual equality. Of course, we have the UN General Assembly versus Security Council, especially the Big Five. Then we have the UN Charter Preamble, well, will be the peoples of the nations. Then, of course, I want you to go back to this concept of horizontality of PIL. Of course, the implementation of norms usually depends upon self-help and self-restraint on the part of formally equal participants in the legal order. Thus, there is no compulsory procedure for the resolution of the appeal to the higher level in the legal system. So that is it. Our initial discussions on fundamental state rights, of course, tackling out on existence and self-defense, sovereignty and independence, and well, the right to equality.